founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Informed Consent and Claims for Unauthorized Medical Treatment. My name is Naveen Joshua. I'm an associate with Mawing Kwai and Associates, and I will be your moderator for today's session. Before we start today's talk, let me introduce the firm and what we do. Mawing Kwai and Associates is a mid-sized law firm that was founded in 1985 by Dato' Mawing Kwai. Our able team today comprises of 21 lawyers and a support team of 25. Dato' Ma is today a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with SMEs, family businesses, and individuals. We are a full-service law firm with a corporate department, a dispute resolution department which includes litigation, adjudication, and arbitration, a dedicated employment and industrial relations team, and also a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus area, which are supported by talents from both our corporate and dispute resolutions teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcasted live. But with the COVID-19 movement control order, we have moved online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. In the event you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now, allow me to introduce our two knowledgeable speakers for the day. I'll begin with Ms. Karmen Fung. She's an associate in our dispute resolution and Individuals and Families Department. She possesses a Bachelor of Laws with honors from Cardiff University, UK. She was called to the English bar in November of 2018. She was subsequently admitted to the Malaysian bar in 2020 upon completion of her pupillage. Her practice areas include general litigation, debt recovery, probate and administration of estate, corporate and commercial litigation, joint management body matters, family law matters, and also medical law matters. Our next speaker would be Ms. Ashvinderjeet Kaur. She is an associate in our dispute resolution team. She possesses a Bachelor of Law with honors from University of Manchester in UK. She was called to the English bar in November of 2019 and subsequently admitted to the Malaysian bar in 2021. Her practice areas also include general litigation, debt recovery, construction, litigation, and personal injury matters. Please do not forget to post your questions if you have any of them in the Q&A chat box provided. There are a few talk points ahead of us. For simplicity and for ease of reference, Ms. Karmen would be speaking on the understanding informed consent and its exceptions, the process of obtaining consent for treatment. Subsequently, Ms. Ashwinder will then be speaking on claims for unauthorized medical treatment and practical tips for doctors and patients. Without further ado, I would like to pass the floor to Ms. Karmen Fung. Karmen, take it away.
Hi, thanks Naveen. I'll share my screen. Yeah. Okay, so thanks Naveen for the warm introduction, and hello everyone, good afternoon. I'm Karmen, and today I'll be addressing the first two talk points, and after that I will be passing the floor to my colleague Ash to take over for the last two talk points. So before we delve into the main topic, maybe it will be helpful for me to first explain what consent is and also informed consent. So consent is a voluntary agreement by a person to another, and it is an actual willingness that an act shall occur. Consent can also be known as an act of reason and deliberation, which means a person who has sufficient mental capacity to approve or assent a decision after a thoughtful consideration. So similarly, informed consent can be said to have been given based upon a clear appreciation and understanding of the facts, implications, and future consequences of an action. So for an example, before giving an informed consent, the person concerned must have adequate reasoning capacity and also possesses of all relevant facts and have at that time consent is given. So the informed consent by a patient is vital in every medical treatment or procedure, as every patient is entitled to have knowledge on all of the essential information regarding their medical treatment. Not only that, in Malaysia, obtaining consent is a legal requirement or procedure to ensure that a patient understands all of the risks and costs involved in a treatment. And therefore, no procedure, examination, surgery, or treatment may be undertaken on the patient without the consent of the patient. So obtaining a patient's consent would establish and also uphold the principles of good medical practice and pave the way for a good quality of professional care. No matter today if you are a doctor or a patient, remember that informed consent is a very important part in the medical treatment, procedure, or even surgery. So there are different types of consent, which includes the following 5 types. I will address them in turn. First is implied consent, where the consent is inferred from a patient's action and circumstances of a particular situation. So implied consent is where the consent is not expressly granted by a person. So express consent, which is the opposite of implied, this may be done in oral, non-verbal, or written form, where consent was given expressly to the doctor. Moving on to verbal consent, this type of consent is given using verbal communication by a patient to the doctor. And then we have non-verbal consent, which uses non-verbal communication, such as nodding or extending the arm to the doctor for a treatment. Then, of course, we will have our informed consent, which I've explained earlier, whereby a patient is informed of the nature of the treatment, informed of the possible alternative treatments and the potential risks and benefits of the treatment. So after understanding the importance of informed consent and also the different types of consent, we then may be wondering, are there any exceptions where consent is not required? So the short answer to this is, of course, yes, there are always exceptions to the general rule. So there are two situations where consent is not required from the patient. We will address them in detail. Firstly is during an emergency situation. So Regulation 48 of the Private Healthcare Facilities Services, Regulations 2006, says that consent of a patient may be dispensed with when the medical practitioner believes that any delay would endanger the life of the patient. So the two keywords here to remember is delay and also endanger. So when this situation happens and the doctor decides that any delay would further endanger the lives of the patient and therefore consent is not required, this must be supported with the consent of another registered medical practitioner. And this consensus must be clearly stated in the statement and have both of the medical practitioners to sign on it to safeguard their interests as well. So emergency is one of the exceptions. And another exception is where a consent is not needed is where there is a court order. So if a certain treatment is ordered by a court of law, the consent of a patient may not be required. For an example, the court may order for a specific treatment of a minor, or where a court has ordered that a patient has to be on life support. In such circumstances supported with a court order, then consent may not be required. We'll move on to talk about the consent for treatment of minors. So what in such situation, if the patient is a minor, do they need to give consent? So it is worth noting that a patient generally under the age of 18 does not have the capacity to give a valid consent. The next question we will ask then, who can give consent on behalf of a minor? So the responsibility will then fall on the parent for their children's welfare under the age of 18 to provide consent on behalf of their children. If a minor is present with an adult other than a parent, the medical practitioner should ascertain the relationship of the adult with the minor. So whether the adult is the child's guardian or not. If the relationship is unable to ascertain at the point of time, then the medical practitioner should put on hold any medical procedure or treatment unless the two exceptions above happen, which is the emergency situation and the court order. So next we will move on to discuss the consent for treatment of incapacitated person. So these incapacitated persons are referring to patients who has impairments to reasoning and judgment, which may make it impossible to give a valid or informed consent. So in this kind of situation, when treating incapacitated person in an emergency situation, the procedure will be the same as outlined for the general emergency treatment, as I've mentioned earlier, where there are situations which any delay would endanger the life of a patient, the two keywords. And when this happens, consent is generally not required for treatment of incapacitated person. On the other hand, where there is a non-emergency or elective situation, the consent must be obtained from the relative, next of kin, or legal guardian. So for this, Section 77 of the Mental Health Act provided shed some light on the issue of obtaining consent for incapacitated person. So the first point shows that the consent for a conventional treatment is generally not required for incapacitated person. However, if an incapacitated person is required to undergo surgery, electroconvulsive therapy, or clinical trials, consent may be given in another form. So then we'll ask what does another form means. So in instances where consent is required, the consent must be first obtained from the patient himself. So I've listed down 1 to 3, and it's according to priority list. So firstly, you must obtain consent from patient himself if he's able to give consent. However, if the patient himself is unable to, then the next alternative is to look for their legal guardian. So legal guardian is for a minor, and in a case where for an adult, you should look for the relative. The same practice applies, so the medical practitioner must ascertain the relationship of the legal guardian or the relative to the patient. If neither the patient himself is capable of giving consent, or you are unable to ascertain the legal guardian or the relationship, then the consent may be obtained from 2 psychiatrists. So one of the 2 psychiatrists must be the attending psychiatrist of the incapacitated person, which is the patient. Next, I'll move on to the points on the process of obtaining consent for treatment, and also certain requirements that must be found in a standard consent form. So for this, the Malaysian Medical Council has provided a simple, not exhaustive guideline for the process of obtaining consent for a treatment. So as we can see, firstly, there must be a doctor-patient relationship. So the medical practitioner and patient must have met or know each other through consultation. So the next thing is there must also be a personal contact with the patient. This means that the medical practitioner who is doing or conducting the medical treatment or procedure must meet with the patient beforehand, and the patient is also aware that this medical practitioner will be conducting the medical treatment or procedure. And then we'll move on to the medical practitioner must then explain the nature of the procedure to the patient, the objective of the intended procedure, and any other alternative procedures, so that the patient is also aware of their choices. And then the medical practitioner must also explain any possible risks and complications that might arise out of the medical treatment or procedure, or even surgery. So it is most advisable for the medical practitioner or treating doctor who will be performing the medical treatment to obtain consent from the patient. So these are the process and also the prerequisites for obtaining consent for treatment. So we move on to see that section 47 of the Private Healthcare Facilities and Services Regulation 2006 shows that consent obtained or caused to be obtained under this regulation shall be in writing. So it is actually a requirement under the Act for all consent to be in writing. Notwithstanding that, when consent is not taken in standard consent form, or where standard consent form is not available at that time, at a particular time where when the doctor would like to take the consent should be recorded in the patient's case notes or record, or any medical record that the patient had been informed and had consented to a particular procedure or surgery. So you should at least put in writing if you don't have the standard consent form. So this is also to protect the interests of the doctors and also the patients. So generally, generally a standard consent form should also include the following details. So first is the patient's data, the patient's name, IC, address, and also gender, and all the basic information. And standard consent form should also have the name of medical procedure or the treatment or the surgery, the type of anesthesia, and the name of the registered medical practitioner performing the medical procedure. Yeah, so this includes the name and also the registration of the doctor. And next is the permission to proceed with any additional procedure that may become necessary during the surgery. The standard consent form also contains a statement which states that the medical practitioner has explained to the patient the nature of the procedure, treatment or surgery, and also the potential material risk. And lastly, for a standard consent form, you must obtain the signature of the patient or next of kin, and also their IC number and the date of the consent was taken. And the signature of the medical practitioner must be there as well, together with the name stamp and the date. And lastly, there must be a signature and name of witness and also the date where they sign on it. So so I'll end with a piece of advice that on my end. So when doctors, when obtaining consent, we must always bear in mind that whatever decisions made must be in the best interest of the patient. And we must always bear in mind that obtaining consent is important unless the two exceptions applies. So with that, I will now pass the time to Ash to address on the next 2 talk points. Over to you, Ash.
Thank you, Karmen. I will now cover the 3rd and 4th talk points. Every patient has a choice to choose whether or not to undergo a proposed procedure, surgery, examination, or treatment. Performance of a procedure upon a patient without his or her consent is unlawful. Rights of a patient to refuse to consent to medical treatment is protected under the tort of battery and tort of negligence. A medical professional who performs treatment upon a mentally competent patient without their consent could be liable criminally in the law of battery. However, civil actions are usually initiated instead based on tort of negligence and in tort of battery. An action in tort of battery will be successful only if there is a complete absence of consent. A battery would have been committed where there has been a direct act of the medical professional which has the effect of causing contact with the body of the patient without the patient's consent. Battery typically involves intentional application of unlawful force to another person. In medical law, this means that a doctor may only carry out a medical treatment or procedure which involves contact with a patient if there is a valid consent by the patient or another person authorized to consent on the patient's behalf. For other medical decisions which do not involve touching, and a patient who is inadequately informed about that would not be able to bring an action in battery. For example, a claim in battery would be successful where a totally different procedure has been performed on a patient from that was initially consented to. An action in negligence will be more appropriate where there is a lack of disclosure of risk or lack of clarity regarding whether consent is informed. In order for there to be a successful action in tort of negligence, there needs to be first, a legal duty of care owed by the doctor to the patient, a breach of that duty of care by the medical professional, and some harm must be suffered by the patient which is caused by the breach, and the harm must not be considered to be too remote. The federal court in the case of Fu Fiona recognized that a medical doctor has a duty to disclose material risk and not any risk associated with a treatment being given. The practitioner is duty-bound by law to inform his patient who is capable of understanding and appreciating such information of the risks involved in any proposed treatment so as to enable the patient to make a choice whether or not to proceed with the proposed treatment. The Whittaker test states that a risk is material if in the circumstances of the particular case, a reasonable person in the patient's position, if one of the risks would likely attach significance to the risk. The Malaysian Medical Council guideline provides that while a patient might consent to a procedure after being informed in broad terms of the nature of the procedure, this consent will not amount to an exercise of choice unless it is made on the basis of relevant information and advice. Relevant information includes disclosure of possible risks, which the patient ought to know or should know. A medical practitioner must inform the patient in a manner that the patient can understand about the condition, treatment options, benefits, effects or complication, and the likely result if treatment is not undertaken to enable the patient to make his or her own decision. A medical professional would breach their duty of care where their conduct falls below the standard that the law has set. A doctor would breach his or her duty of care if it can be proved that a reasonable person in the patient position would likely to attach a significance to a risk and the doctor had failed to warn the patient of that particular risk. The last element of negligence is causation. The damage suffered by the patient must have caused by the breach of the doctor's duty. The patient must prove not only that the doctor was at fault and that they suffered a recognizable harm, but also that this was as a result of the doctor's actions. For instance, if it can be proved that the patient would not have undergone a particular treatment and or surgery had the patient been advised of that material risk involved to the treatment, a claim in negligence would be made. Other than initiating a civil action, patients can also complain to the hospital under the hospital's grievance mechanism procedure, or make a complaint to the Malaysian Medical Council for breach of ethical duties, or launch a police report. The MMC guidelines provides that failure to obtain a patient's consent or disclose material risk may be interpreted as failure of the standard of care, resulting in a disciplinary inquiry by the Medical Council. I will now share some practical tips for doctors and patients. It is generally required that only fully registered medical practitioners may take consent for a procedure, examination, surgery, or treatment from a patient, and also perform the procedure, examination, surgery, or treatment for which the consent has been taken. The primary responsibility to obtain consent rests on the practitioner who performed the procedure, surgery, treatment, or examination. This is based on the requirement that the practitioner taking the consent and performing the procedure examination will be able to explain to the patient all details of the proposed treatment. In the event of the practitioner taking the consent and the practitioner performing the particular procedure are two different registered medical practitioners, the final responsibility and liability will rest on the practitioner who performed the procedure, who should, before performing the procedure, confirm the nature of the information given to the patient by the other practitioner in the course of taking the consent. It is advisable that doctors do take some time out to speak and explain the proposed procedure in details to patients. A general consent form is insufficient if patient is not informed of the relevant risks of the proposed procedure. The MMC guidelines recommends that practitioners do provide additional information on risks and adverse effects of any procedure in written explanatory documents which the patient or next of kin can read, request further explanation where necessary, understand and append a signature to that effect. These notes will be considered as an annexure to the main consent form signed by the patient or next of kin. Where such notes or document are not available or not in standard use, the practitioner may note down the risks or adverse effects as explained to the patient in the patient's case notes and duly signed with a date. Patients are advised to voice out concerns regarding the proposed procedure that they are undergoing during consultation. Patients are also advised to take plenty of time to understand the proposed procedure, and patients are at all material time entitled to withdraw their previous consent if they change their mind at any point before the procedure. That's all from me. I will now pass on the floor to our moderator, Naveen.
Thank you, Karmen and also Ashwinder. We will now take questions from the participants from the Q&A chat box. I will start with the first question. Can I choose to not give consent in medical treatment? Can Karmen, you want to take this?
Oh, yeah. Okay. So the question, if I may recall, is can I choose not to give consent in the medical treatment? So the answer is yes. Every individual is entitled to refuse treatment provided they have sufficient mental capacity to do so. So you also, so do take note that forcing a medical treatment on a competent patient who has validly refused treatment may amount to assault or battery, as mentioned by Ash earlier. So the answer is yes, you can refuse. To give to not give consent to medical treatment. Yeah.
Thank you very much, Karmen. The next question: before commencing a suit, are patients entitled to their medical records? Ash, you want to take this?
Yes. So the question is, before commencing a suit, are patients entitled to the medical records, right?
Yes.
So yes, all patients have the right to obtain a copy of their medical records from the hospital. However, if the particular hospital is being difficult or refuses to release the medical records, patients can file an application to courts to obtain a court order to force the hospital to release the medical records.
Thank you, Ash. The next question, the question is phrased in such a way: private healthcare facilities regulations, are these regulations only applicable to private healthcare? Karmen, you want to take this?
Yeah, I can take this question. So for Private Healthcare Facilities and Services Act 1998, or even the regulations 2006, this does not apply to government healthcare facilities. Okay. Yeah, and only to private healthcare, yes.
Okay, that's very useful. Thank you, Karmen. The next question: what is the amount of damages that a patient would be entitled to in the event the doctor fails to advise on a material risk which led to an injury towards the patient? Ash, you want to take this?
Yeah, I'll take that. If the patient is successful in proving his or her claim in court, the amount of damages that will be awarded would depend on the type of injury and losses suffered by the particular patient. There is no fixed amount. Other factors such as whether or not the patient is able to work or whether the person requires further treatment would be a factor that the court will take into account to consider the amount of damages that it wants to award.
Okay, thank you, Ash. The next question: can consent be dispensed with a AMD? Karmen, you want to take this question?
Yes. Okay. Thank you, Naveen. So the question is, can consent be dispensed with AMD? Is it?
Yes.
Yeah. So for this situation, the patient would have considered to have given his consent upon signing the AMD. The AMD would only take effect when the patient is no longer able to consent to the treatment. However, if the medical practitioner has any doubts on the instructions, or even the validity of the AMD, it would be best to consult legal advice. Yeah.
Okay. Thank you. I think with regards to questions, which is confined to the topic, I think that would be all with regards to the question and Q&As. We would then move on. I would like to thank Karmen and Ashwinder for your lovely insights and your opinions as well. Before we conclude, I have a few announcements to make. Let me share my screen. Okay. First, please join us again for our upcoming talks at the website stated in the slide. Please do take note of the website address stated in the slide to sign up for our upcoming talks, which would be held starting from January 2022. Secondly, please do fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. Thirdly, do follow or like our social media accounts as listed in the slide. We have YouTube, Twitter, Instagram, LinkedIn, and also Facebook. Fourthly, if you would like to speak with any of our lawyers, we do offer a complimentary 30-minute consultation over the telephone or over video conference. Please fill in the form on our website, and the link is also posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session to be informative and useful to you. We also like to thank everybody and see you at our next talk. Take care. See you guys. Bye. Thanks, Karmen and Ash.
Thank you, Naveen.
Thanks.